Scott Duncan presiding.
All right, everybody can be seated. All right. All right. My understanding is Mr. Barnes also with Judge Hilliard?
Paper approach, Your Honor.
All right.
Thank
Yep.
you.
Do you want lunch to be ready?
11:30.
11:30?
Yeah, okay. Okay, all right, what we'll do is we'll be in recess, and then hopefully Mr. Barnes will be here in the next few minutes, and we will get started, and I'll step off and just let me know
Yes, sir.
when he gets here.
Please rise for the judge.
everybody be seated. We'll get Ms. Kuhn in here. Okay.
I'm sorry, Judge.
Couple of things. Mr. Alderman has requested that that I read the jury instructions first before closings. And I've done it both ways. I assume that y'all will be referencing the jury instructions.
To save you time, Judge, I always ask that it be read before.
Okay, all right, then I'll go ahead and read the instructions before the closings. So let me give a copy to the court reporter, copy to, well, I'll give this one to you after I read it. And then, I believe I've already given counsel copies of it.
Yes, sir.
And usually do y'all want me to, I think I normally, when I do this, I stop at 3.12, and then I do 3.13 after the closings. Is that okay?
That's fine, Judge.
Absolutely.
Okay. Okay. Anything we need to put on the record?
Not from the state, Judge.
Not from the defense, Your Honor.
These are the alternates. Okay. Okay. Let's go ahead and bring the jury in.
I was complaining to you.
Please rise for the jury.
Okay, everybody can be seated. Okay, members of the jury, both the state and the defendant have now rested their cases. In a few moments, they will give you their closing arguments. But before they do that, I'm going to go ahead and read you your jury instructions. Now, each of you will receive a copy of these instructions when you go back to deliberate. So don't feel that you have to take everything down in writing of what I'm going to say. But I want to go ahead and give you your jury instructions beforehand. And then the attorneys will do their closing, and then I will give you some final instructions. So members of the jury, Bree Kuhn, the defendant in this case, has been accused of the crime of first-degree premeditated murder. Bree Kuhn is accused of first-degree premeditated murder in count 1. First-degree murder includes the lesser crimes of second-degree murder and manslaughter, all of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find Collin Turner was killed by Bree Kuhn, you will then consider the circumstances surrounding the killing in deciding if the killing was first-degree murder or second-degree murder or manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. The killing of a human being is excusable and therefore lawful under any one of the following 3 circumstances. 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3, when the killing is committed by accident and misfortune resulting from a sudden combat if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I now instruct you on the circumstances that must be proved before Bree Kuhn may be found guilty of first-degree premeditated murder or any lesser included crime. To prove the crime of first-degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Collin Turner is dead. 2, the death was caused by the criminal act of Bree Kuhn. 3, there was a premeditated killing of Collin Turner. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which she is accused, there may be evidence that she committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of first-degree premeditated murder are second-degree murder and manslaughter. To prove the crime of second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Collin Turner is dead. 2, the death was caused by the criminal act of Bree Kuhn. 3, there was an unlawful killing of Collin Turner by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is eminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. To prove the crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. 1, Collin Turner is dead. 2, Bree Kuhn intentionally committed an act or acts that caused the death of Collin Turner. Every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. If you find that Bree Kuhn committed second-degree murder or manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime she personally carried, displayed, or used a firearm, you should find her guilty of second-degree murder or manslaughter with a firearm. A firearm is defined as any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive, the frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, or any machine gun. If you find that Bree Kuhn committed second-degree murder or manslaughter, but you are not convinced beyond a reasonable doubt that she personally carried, displayed, or used a firearm, then you should find her guilty only of second-degree murder or manslaughter. If you find that Bree Kuhn committed second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime she discharged a firearm and in doing so caused the death of Collin Turner, you should find the defendant guilty of second-degree murder with discharge of a firearm causing death. If you find that Bree Kuhn committed second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime she discharged a firearm, you find the defendant guilty of second-degree murder with discharge of a firearm. If you find that Bree Kuhn committed second-degree murder, you also find beyond a reasonable doubt that during the commission of the crime she actually possessed a firearm, you should find the defendant guilty of second-degree murder with actual possession of a firearm. A firearm is legally defined as any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive, the frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, or any machine gun. To actually possess a firearm means that the defendant carried a firearm on her person. It is a defense to the crimes of first-degree premeditated murder, second-degree murder, and manslaughter if the actions of Bree Kuhn constituted the justifiable use of deadly force. Deadly force means force likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm. Bree Kuhn does not have the burden of proving that she was justified in using deadly force. Instead, for you to find the defendant guilty, the state must prove beyond a reasonable doubt the defendant was not justified in using deadly force. The law on justifiable use of deadly force is as follows. Bree Kuhn was justified in using deadly force if she reasonably believed that such force was necessary to prevent imminent death or great bodily harm to herself or another. Bree Kuhn had no duty to retreat before using deadly force. If Bree Kuhn was in a residence in which she had a right to be, she had no duty to retreat and had the right to stand her ground and use force, including deadly force, if she reasonably believed that such conduct was necessary to prevent imminent death or great bodily harm to herself or another. In deciding whether Bree Kuhn was justified in the use of deadly force, you must consider the circumstances at the time the force was used. The danger need not have been actual. However, to justify the use of deadly force, the appearance of imminent danger must have been so real that the defendant actually believed the use of deadly force was necessary. Moreover, to justify the use of deadly force, a reasonably cautious and prudent person under the same circumstances would have believed the use of deadly force was necessary. If you find that Bree Kuhn, who because of prior threats or difficulties with Collin Turner had reasonable grounds to believe that she was in danger of death or great bodily harm at the hands of Collin Turner, you may consider this fact in determining whether the actions of Bree Kuhn were those of a reasonable person. If you find that at the time of the alleged first-degree premeditated murder, second-degree murder, or manslaughter, Bree Kuhn knew that Collin Turner had committed an act or acts of violence, you may consider that fact in determining whether Bree Kuhn reasonably believed it was necessary for her to use deadly force. In considering the issue of self-defense or defense of another, you may take into account the relative physical abilities and capacities of Bree Kuhn and Collin Turner. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are, did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses, with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusions about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove her innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by her decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to, 1, whether when the defendant made the statement she had been threatened in order to get her to make it, and 2, whether anyone had promised her anything in order to get her to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged or guilty of such lesser included crimes as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to the crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. It is as follows. I know it's going to be hard for everybody to see this up here, but I want to give you an outline of the verdict form. It'll have the caption of the case, and then it'll say, "We, the jury, find as follows as to the offense charged in the indictment." You have the choice of guilty of first-degree premeditated murder as charged. You have the choice of guilty of second-degree murder, a lesser-included offense. If that is your choice, there are questions that you have to answer. The first question is, if you find the defendant guilty of second-degree murder, do you further find beyond a reasonable doubt that during the commission of the crime the defendant did personally carry, display, or use a firearm? There's a place to check yes or no. The second question, if you find the defendant guilty of second-degree murder, do you further find beyond a reasonable doubt that during the commission of the crime the defendant actually possessed a firearm? And there's a place for yes or no. The third question is, if you find the defendant guilty of second-degree murder, do you further find beyond a reasonable doubt that during the commission of the crime the defendant discharged a firearm? A place for yes or no. And then the question of, if you find the defendant guilty of second-degree murder, do you further find beyond a reasonable doubt that during the commission of the crime the defendant discharged a firearm and that such discharge caused death to Collin Turner? You also have the choice of guilty of manslaughter, a lesser included offense. If that is your decision, then you will need to answer this question. If you find the defendant guilty of manslaughter, do you further find beyond a reasonable doubt that during the commission of the crime that did personally use, carry, or display a firearm? And there's a place for you to check yes or no. And then you have the choice of not guilty. And there's a place for the foreperson to sign and date the verdict form. And I will give you further instructions on that. I will have some closing instructions for you. But at this time, the attorneys will now present their final arguments to you. Please remember that what the attorneys say is not evidence or instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. So you have the state go first, then the defense, and then the state will have rebuttal argument. All right, Mr. Alderman, are you ready to proceed?
Yes, Your Honor.
And do you want me to go ahead and turn the
Yes, sir, please.
projector on?
Please the court, Mr. Barnes, Mr. Etheridge. Ladies and gentlemen, thank you for your time and attention this week. Before I start running through my closing, I do want to point out, obviously, on Tuesday, Mr. Etheridge and I gave opening arguments or opening statements, and we talked about the evidence that we anticipated that you would hear and see during the week. Now, I always think that a trial is a sort of like a living, breathing organism. No matter how much work and plan you put into it, things change. Usually it's nobody's fault. That's the way it is. So what's important at this stage is, as the judge just told you, what the attorneys say is not evidence. What I told you in opening statements, what Mr. Etheridge told you in opening statements, is not evidence. Your verdict should be based on evidence that you heard from the witness stand and in the form of the exhibits. So if you heard something in opening that you didn't hear during the trial, you should disregard it. Now, I do want to talk to you about the jury instructions. The judge just read them to you. Each of you will have a copy that you get to take back with you into the jury room. And it is my job, the judge has explained the law to you. It is now my job to explain how that law pertains to the facts of the case. So what is Ms. Kuhn charged with? She has one count, first-degree premeditated murder. The judge read the three elements of the charge. Firstly, that Mr. Collin Turner is dead. The judge read you a stipulation on Tuesday. Both sides agree. Obviously, Mr. Collin Turner is dead. Second element, that his death was caused by the criminal act of Ms. Kuhn. Third, there was a premeditated killing of Collin Turner. The judge just read to you the definition of premeditation. I talked about it briefly on Monday. It requires a conscious decision to kill. It means that somebody is not trying to wound, they're not trying to maim, they're not trying to injure. They make a conscious decision to take another human life. After that decision, there must be enough time for reflection. Now, the law doesn't tell you how long that must be. Seconds, minutes, days. There must be enough time for reflection between the decision to kill and the act itself. And again, so it is up to you to decide, is this enough time for reflection? Now, the example I often use for first-degree murder is, let's say I'm in an argument with somebody here in the courthouse. I walk out to my car, get my gun, come back and kill the person. That would very likely be premeditated murder. I've had time for reflection. I walk out, get my gun, I walk back. It's a short time frame, seconds, a couple of minutes. There is time for reflection. It's not an instantaneous decision, but there is time for reflection. Now, what's also key about that is it's time for reflection, not time for meditation or to, go to your happy place and cool down and make a calm, rational, logical decision. That is not what premeditation is. Someone can still be aggravated, mad, and it's still premeditated murder. I get my gun from my car and I'm coming back up here. I'm still mad. Otherwise, I wouldn't kill the person. But that is premeditation. So it's important to know what is required. An intent to kill, time for reflection. As it pertains to this case, look at the actions of Ms. Kuhn. And obviously, when it comes to premeditation, we're not mind readers. Right? We don't know exactly what was in her mind. That's why the instruction tells you, you look at the circumstances of the killing. You look at the physical evidence that indicates what the person's intent was. What was the person intending to do? So ask yourself, when Ms. Kuhn approaches the door to the garage, what was her intent? Her intent was to kill her husband. How long did she premeditate? We'll never know. couple of minutes, 10 minutes, no way to know. But there was enough time for reflection. She intended to kill him as she's walking to that door. That is premeditated murder. Judge read to you the lesser included crimes, second-degree murder and manslaughter. I do want to touch on them briefly just to explain the differences. So second-degree murder also has 3 elements. You'll notice that the first 2 are the same as first-degree murder. Collin is dead, and his death was caused by Bree Kuhn's criminal act. It's the third element there is the difference. Third element for second degree is that there is an unlawful killing of Mr. Turner by an act eminently dangerous to another, demonstrating a depraved mind. Second-degree murder does not require an intent to kill. It's an intent to do an act that is eminently dangerous to another, but not necessarily to kill. It may seem like a small distinction, but it's a very large difference. Example I often use is if I shoot somebody in the leg, they bleed out and they die. Shooting somebody in the leg is eminently dangerous. It's certain to cause great bodily harm. Was I intending to kill them? Maybe, maybe not. These are the definitions that the judge just read to you of eminently dangerous. Has to be reasonably certain to cause bodily injury. It's done from ill will, hatred, or spite, and indicates an indifference to human life. Now, it's important to note, as you're looking at this definition of second-degree murder, you may be thinking to yourself, well, she did all of these things. Right? She did an act that was eminently dangerous to another. That act showed an indifference to human life. So as you're looking at these, you may think this fits what she did. But it's important to remember that, yes, she did all of this, but she did more than that. Because second-degree murder, there's no intent to kill, there's no premeditation. So when you look at those elements of second-degree murder, yes, she did all that, but she did more. That's why it's a lesser charge. The other lesser charge is manslaughter. There are 2 elements. Again, first, Collin is dead. Second, that it was an intentional act that caused his death. Now, with manslaughter, the act has to be intentional, but not the death, not the result. So, example I usually use is if I intentionally punch someone, that's an intentional act. They fall, hit their head, and die. That's an intentional act that has resulted in death. I did not intend to kill the person. I did not intend the person to suffer great bodily harm. My intent was to punch them. That's manslaughter. Intentional act results in death. Again, that is not what Bree Kuhn did. Well, she did do that, but again, she did much, much more. So it's a lesser charge. So again, just remember when you're looking at those, yes, she did those, but more. So that's the difference between the three charges. Judge read to you the definition of justifiable use of deadly force. I touched on this briefly on Monday. And you...
Does I have an objection? Can we approach?
Okay.
Mr. Alderman?
Thanks, sir. So Monday we talked about, I'm sure everybody has their own definitions of what self-defense is, and you all agree with me that you would apply the legal definition of self-defense. And this is what the legal definition of self-defense is. The person is justified if they reasonably believe the force is necessary to prevent imminent death or great bodily harm to himself or another. Now, several key words in that are there has to be a reasonable belief. So if somebody, gives me an odd look, and I think they're about to kill me, and I use deadly force, that would not be self-defense because it has to be a reasonable belief. It's not just what I believe. It has to be a reasonable belief. Another important word in that sentence is prevent, i.e., it's something that's about to take place. It's not something that's already happened. There's a difference between revenge and self-defense. Self-defense has to be to prevent a future event. It also requires that it's imminent. In other words, if I tell somebody I'm going to stab you in 2 weeks, that is not an imminent threat. It has to be about to take place. The person is a threat, an imminent threat. It also has to involve death or great bodily harm. So if somebody pokes me in the chest, do I have the right to defend myself? Absolutely. Do I have the right to use deadly force, kill the person? No, because there's no imminent threat of death or great bodily harm. So self-defense is not a blank check. If somebody threatens you or does something, does not mean you just have the right to do whatever you think is necessary. There has to be an imminent threat of death or great bodily harm for you to be justified in using deadly force. Another thing I want to touch on is that there is no duty to retreat. In Florida, if you're in a place you have a right to be, whether it's your home, the gym, on the street, you're in a place you have a right to be, you're not breaking the law, you have no duty to retreat. Commonly, people refer to it as a stand your ground. You get to stand your ground. So, for example, if I'm standing next to my running car and somebody is 50 yards away walking towards me and they're threatening, they're yelling at me, and I can get away safely, I don't have to. I can stand there, stand my ground, wait for that person to approach me. And then as soon as they pose an imminent threat, maybe they're a few feet away, I get to defend myself. But what does that not entail? Right? It's a duty, no duty to retreat. But if that person is yelling at me from 50 yards away, I approach them to initiate a physical confrontation, that would not be self-defense. You don't have a duty to retreat, but you can't advance. There's a big difference between standing your ground and advancing to seek a physical confrontation. It also requires that the danger must be so real that the person thinks that such force is necessary. And it's not, again, it's the last sentence talks about a reasonably cautious and prudent person must believe that the actions are necessary. So it's not what some nervous, trigger-happy person thinks. A reasonably cautious and prudent person must believe these actions are necessary to defend myself or another from what's about to take place. This is the verdict form the judge just read to you, so I'm not going to read through all of it. It looks convoluted. It's really not. Ultimately, you have 4 options: first-degree murder, second-degree murder, manslaughter, not guilty. As the judge read, if you come back second-degree murder or manslaughter, you have to answer the questions about whether this case involved a firearm, which obviously it did. So if you were to find Ms. Kuhn guilty of second-degree murder or manslaughter, you would answer yes, she used the firearm. If you find that Ms. Kuhn guilty of first-degree murder, you check that box at the top, you're done. Judge read to you the reasonable doubt. I'm not going to read it to you. This is the standard that you're to apply, that you're to hold the state to. Not all doubt, not every doubt. I gave you the example on Monday about the rain example. and what is the reasonable conclusion from the evidence. And this standard applies to those three elements of first-degree murder. You believe the state has proven those three elements of first-degree murder? Find it guilty. Another important thing to note is you can have reasonable doubt about things outside the elements. The state does not have to prove every little aspect of the case beyond all reasonable doubt. If you're not sure what color Collin's truck was, like, I'm not sure if it was red, if it was blue, that's fine. That's not an element the state has to prove. So always go back to that I believe it's the second page. What are the three elements the state has to prove? That's it for your verdict to be guilty. Weighing the evidence. Ultimately, your job as the jury is to decide what is credible, what is believable, what is reliable. The attorneys, myself, Mr. Barnes, Mr. Etheridge, we can introduce evidence, but what we think about the evidence doesn't matter. It's your decision. You get to decide what to believe, who to believe, how much to believe. That is your job. And just use your common sense. That's a lot of times what these cases come down to. Use your common sense in evaluating what somebody is telling you. Does it make sense? You can believe or disbelieve any part, any testimony or any evidence. I always think of it sort of like a buffet. You can pick and choose whatever you want to believe, how much to believe. That is entirely your province. 3.9 also indicates all the factors you can use to evaluate the testimony of a witness, which again is a very important job. And you should use these criteria in evaluating every witness that you heard from, both from the state and from the defense. Now you see that many of the state witnesses, a great deal of what they testified to, what they saw, what they heard, what they did, was on camera. That's one of the great things about the body cams, is that we're not reliant on somebody's interpretation or their memory. For example, Deputy Lynn, he had contact with both Collin and Bree right before the murder, about 45 minutes. I think he left about 45 minutes before the shooting. Now we're here 3 years later. We don't have to rely on what he thought they said or what he believed their attitude was. You got to see it and hear it for yourself. So, no disrespect to him, but if his memory isn't that great about what happened, you've seen and heard it. You know what happened. Now, when you apply these criteria to the testimony of Bree Kuhn, you're going to see that his testimony should not be relied upon. Now, I do want to talk about it briefly. So, Mr. Kuhn's testimony, you heard from him about what he heard, and his testimony was all over the place. I mean, right from the get-go, he tells you this call was several minutes, and then seconds later he says the call was 45 minutes. And granted, he probably didn't have a stopwatch on him, but that's a huge difference. He said Collin was dragging Laney by the arm. 30 seconds later, he turns around and said, I never said dragging. You literally just said it 30 seconds ago. We went back and went round and round in circles about the statements early in the day about whether Collin was refusing to watch the kids or whether he was kidnapping the kids. And he said both. And he even said on the stand, how can it be both? I said, I don't know. I don't know. There was all the things that he was convinced that he told the police before they started recording. About dragging Laney by the arm, about Collin, or Bree saying that Collin's threatening to kill the kids, he's throwing her down. And he believed that he said all these things he told the police before they started recording, or he must have said it while Zoom was glitched. And I recalled Deputy Kelly, but I hope you understand that that's not how murder investigations proceed. These detectives don't have a full-on interview and then say, hey, now let's start the recording. I asked Detective Kelly, or Sergeant Kelly now, did you do that in this case? No. Have you ever done that in your career? No. Would you ever do that? Of course not. Although even then, when they're talking to him, they say, tell us everything. And he sat there and told you, oh, I didn't mention all the things I mentioned before because I didn't want to be redundant. He also talked about how them showing up, and he was so taken aback, and how unprofessional they were to just simply show up. And he was shell-shocked these detectives show up to talk to him. He's saying that he is the only witness in a murder case. He's on the phone. He hears the entire thing. He hears his sister being attacked, the only witness to a murder case, and then he is shell-shocked that homicide detectives turn up to talk to him. He should have welcomed them with open arms. Instead, he sat here and seemed to have absolutely no clue what he told them. You're going to rely on his memory and his version of events? No, you shouldn't. Ultimately, it was, I'm not sure exactly what his end testimony was, but the takeaway was that he hears this scuffle, altercation, fight. He hears Bree being hit. She's reporting, Al, that hurts. Collin, you're hitting me. Things that she's saying that Collin's doing. He hears kids screaming. Then he hears gunshots. All part of one sequence. He tried to sort of equivocate between immediately, right after. He said it was all one sequence. This fight, gunshots. It sounds good, right? It sounds like somebody defending themselves. She's being attacked. He's threatening the kids. She's got to defend herself. You've heard the 911 recording. Right? Collin was not in a physical altercation. He was not attacking anybody. He was not dragging anybody. The kids weren't screaming. He's out on the phone having a calm, rational conversation. None of that was taking place. Two conclusions come to mind. Either Mr. Kuhn is mistaken about what he thought he heard, or perhaps he did hear, and he is right about some of the things he heard. And I asked him, can you tell between someone hitting themselves, someone being hit by somebody else? No, of course not, on the phone. Because he's relaying, hearing this ruckus, this fight, right before the shooting. Right? Logically, that did not take place in Collin's vicinity. Otherwise, we would have heard it. He's locked outside in the garage. She's inside with the kids. What he's hearing could not have taken place near Collin. So if he's hearing somebody being hit, ow, that hurts, Collin, stop. She's doing that inside the house. Walks to the door, shoots Collin in the back. She now has a witness and an alibi for murder. Is that what happened? We don't know. What we do know is that Collin was not attacking her. So if what Eric Kuhn is reporting is accurate about this fight, it didn't involve Collin. And Deputy Hartberger told her earlier that morning, or early in the afternoon, when he did not arrest Collin, was there another witness? Now, he wasn't suggesting to her to sort of find a witness, but she knew something would happen. She needed another witness. Now, hey presto, she has a witness. At the end of the day, you just got to use your common sense. And you get to decide what to make of his testimony, what to believe, how much to believe. I would urge you just to disregard the whole thing. You can do that. You know, just because there are conflicts in the evidence doesn't mean that you have to believe one side. If somebody gets on the stand and insists that 2 + 2 = 17, you can go back to the jury room and say, I don't believe it. Because his statements not only were inconsistent in and of itself, it was also completely different than the version his sister gave. It's also contradicted by the physical evidence and any degree of common sense or rationality. Anyway, I'm not going to spend any more time on that. I hope you evaluate his testimony as you should. And at the end of the day, he's our brother. He told you about she was my protector growing up. Now she's on trial. And it's his turn to be the protector. So let's talk about the state's case. So that day, things got started, 12:54, and Ms. Kuhn calls 911 and reports that Collin has pushed her and thrown her down. And then another interesting aspect of that 911 call is that the operator then tells her, do not interact with him. Right? Makes sense. She's reporting a physical altercation. Don't interact with him. So what does she do? Goes and grabs her phone and starts recording him, trying to provoke him into an argument. And I'm not going to play that whole thing. You have it in evidence. Those last couple of minutes, I think give you a good insight. If she goes out there and is trying to talk to him, and he says, I tried to talk to you. No, you didn't. He says, I tried to talk to you last night. And again, she is surreptitiously recording. She's got the phone held down by the side of her leg. Common sense would tell you, when someone's recording their partner, they're on their best behavior. Right? So when she's having this, I don't know if you call it an argument, this discussion with him, she's on her best behavior. Collin isn't. Clearly he doesn't know he's being recorded because the phone's down by her leg. So that is Collin as he is. And she kind of talks over him, and so it's hard to hear, but you can definitely hear it. When she's sort of going after him, he says, if you talk, I will listen. Depending on what you say, I may or may not respond. That is a very calm and rational response in an even tone. Like I said, and that was Collin in this discussion. And then they kind of go back and forth. I don't trust you with the kids. I don't trust you with the kids. I think what you get from that is she wanted an argument and was frustrated that he just did not seem to want to argue with her. Then she starts picking at him, oh, you're on disability for this, and, because she's talking about he's emotionally unstable. Given her position and the things she's been through, the old saying about if you live in a glass house, you shouldn't throw stones, because he could have come back and said, well, yeah, you've been Baker acted and you attempted to commit suicide. He didn't say any of that because it just seemed like he just didn't want to argue about it. So, but that is a good insight into sort of their relationship. And at that time, she's reporting, he's just throwing me down. She wanted him to say or do something stupid to the cops. So when they arrive, what did she tell them right off the bat?
What are you doing? What's going on today, ma'am?
So my husband is trying to take the kids.
What's up, big guy?
He threw me on the floor and pushed me against the wall.
And this all happened.
So even here, and every time after, the first thing out of her mouth every time is, he's trying to take my kids. And then she relates, he pushed me down. And then a few minutes later is when she talks about, she makes the comment to Deputy Hartberger that he either didn't catch or didn't acknowledge about he raped me over the weekend. But then she also made an interesting comment to her dad.
We had such a good weekend. He's my best friend.
Hold on, speak clearly.
We had such a good weekend together. That's what she's telling her dad later. Now, what does Collin say about what's been going on this day?
she called you right now because she figured out that I want to take my kids to my parents' house in Georgia for her and I to have more for me. I guess me to have a break from her.
He wants to go to Georgia for a break.
This morning?
Yeah, this is probably right around 2 a.m. at this point.
Okay. So what happened today causing her to pick the phone up and call? I guess she called 911. I didn't look.
She found out I was packing my car.
That's what the upset was?
Yes.
That you're going to Georgia to see their grandparents?
Yep.
And your parent?
Yeah, they're my parents.
Okay. And your kid's grandparent.
So Collin is not just talking about leaving. He's actively packing his truck. This isn't just sort of a idle speculation. He's packing his truck. He's getting ready to leave. And she knows that. This is from our interview later on the evening.
He was threatening to take the kids.
Okay.
He said that since I had tried to kill myself a couple months ago, that no judge in the world would give me custody of the children. And he was packing.
So she says he's trying to take the kids. He's packing the truck. And she said, no judge in the world would give me custody because of her recent psychiatric issues. So she knows he's leaving. He's about to leave. He's going to take those kids. And she knows she's not going to win this custody battle. So she has to stop him from leaving, one way or another. Now, I wish I could stand here and say that nobody would ever accuse anybody of something falsely to gain custody of their kids, but that's not the world we live in. She had to stop him from leaving. He's packing his truck. He is leaving. She's got to stop him from leaving. And so conveniently, right before he's leaving to Georgia, she says he pushes me down. She wanted him taken to jail. And I think you can see that through her interaction with Hartbarger. Because when she realizes that's not happening, she doesn't fill out the witness statement he gives her because she's not getting what she wanted. Take him to jail, and then I get custody of the kids. So I think that should give you some insight as to her mindset as to how this all transpired. Now, obviously all the body cams you have, and you can watch any of them as you want. I try to be cognizant of your valued time. So you saw the interactions between them, and Collin's out there with the little kid, and they're looking at the truck, and they leave. And shortly thereafter, she locks Collin outside in the driveway. Why does she do that?
So I closed the garage doors and I locked the door and took the batteries out of the lock so that he could come in and take the kids.
So she locks him outside so that he can't come in and take the kids. Not because he's threatening me or he's going to hit me or she locks him out so he can't take the kids and go to Georgia. That's why she's locking him out. And then he's outside in the driveway in a hot summer Florida day, and he later on said, I was fine with being out there basically because I was away from her. And he calls her command. You heard from Mr. Forehand. And he's saying, she's cut off my access to finances. She's taking my credit cards. And he's looking for help. I mean, he's multiple places he's turning to for help. And unfortunately, he didn't get it that day. So he's out there for a while in the heat by himself, probably happy to be out there in the peace and quiet by himself. So at some point, Lainey wakes up, the 3-year-old little girl. She's crying, and so Bree Kuhn takes her, the 3-year-old, outside to Collin so that Collin can help calm her down.
So I took her out front, and he was still there. I asked her if she wanted Daddy. I gave her to him. And he wouldn't talk to me.
So, and I hope you can hear that. Again, at this point, they still have that space heater running, so it's hard to hear. And in here, unfortunately, the louder you turn it up, it gets kind of echoey or staticky. So again, you can listen to that. But what she says there is, Lainey was crying. I took her outside. I gave Lainey to Collin. And then she says he wouldn't talk to me. She brings him the child so he can calm her down, and he wouldn't talk to me. Shortly thereafter, Collin calls 911. He's now locked outside with Lainey, and you heard her on the 911 call. She's crying, she's upset, she's hot, she's bothered. So he's calling, saying, "Look, now I care because we're both locked out, and I want to go back inside with my daughter." Deputy Jameson Lynn arrives and talks to both of them.
Took my photo ID, all my access to money and everything.
Okay.
And then took the kids inside and locked me out. So I've been locked outside in my driveway
Okay.
for the last couple hours.
Do you live here?
What's that?
Do you live here?
Yeah, we're
Okay.
co-owners for both.
Okay.
So again, I'm locked outside of my driveway. She's taking my stuff. I just want to go in my house.
Something about kids going to Georgia.
Yeah, that was the most closest alligator to the boat.
Okay.
But she was mad that I turned off the Wi-Fi last night, so she
Okay.
washed my laptop in the dishwasher.
Okay.
And that's kind of like the last straw.
You
So
guys,
is
are
it
you
legal?
guys, are you guys still married?
I mean, for now, yeah.
It's still legal. And it's common
Yeah.
property.
Yep.
What's yours is hers, and hers is yours. Unfortunately,
Yeah, so she's
common
not
property.
allowed to stop me from entering my house.
if it's your house and you still live here, by all means, you got to enter your home. However, you got to enter your home.
So a couple of interesting things there. When Deputy Lynn asked him if you're still married, you saw Collin sort of involuntarily glance down at his wedding ring and said, for now. And I think you can see he's just, he doesn't want to talk to her. Deputy also tells him, it's your house. Whatever you need to do, kicking the door, breaking a window, it's your house. You can get in whoever you want. The other interesting thing about this interaction is you see Ms. Kuhn there in the background. And she is just staring him down while he's standing there. I mean, look at her body language. Look at what she's doing. She is staring him down. This is less than an hour before she murders him. And she seems very aggravated. And he's just calmly holding his daughter, talking about what's going on. That is a very powerful visual of what is about to happen and what her state of mind is. So then Deputy Lynn talks to her.
What's going on today?
Well, you guys were out here earlier.
Federal
He was trying to take my kids.
10-4 check.
I'm 10-4, thank you.
He was trying to take my kids to Georgia.
Okay.
I
Are they your kids or are they yours and his?
these two. Well, the
Again, first thing she complains, he's trying to take my kids.
out here because she's used to him and I, so I brought her out here.
Okay.
So he can help calm her down. He snatched her from me and then started trying to use her to,
Okay.
I don't know.
Okay.
He said, she doesn't want to come in the house unless daddy's there.
Okay.
Being manipulative.
Okay.
It's not a
So-
good environment.
So there, she's telling the deputy, he snatched Lainey from me. You just heard her say she went out there and handed it to him. And then she accuses him of, he's being so manipulative. Well, make up your own minds about that. She continues.
Okay. All right. And same thing, if you change the locks, he's got every right to get in the house. However, he's got to get in the house, okay?
Okay.
If he lives here, he's got property here. For the betterment of your daughter, whatever you guys got going on, you got to put aside for the kids. You see what
Well,
I'm
I
saying?
agree, but he told me not to talk to him. So
Okay.
I'm not going to.
Again, she's complaining, he won't talk to me. That's what she keeps complaining about. He won't talk to me.
We can't say, well, you got to stay out in the front yard for the rest of your life. You know what I'm saying?
Yeah. No, I just
at the risk of a
I
potential
didn't
argument.
call you. I just came out.
No, I get it. I get it. But like I said, I'm letting you know. At some point, we got to put our differences aside for the kids, and we got to say, hey, look, you got a guest bedroom, I got my room, or vice versa, whatever it is. I mean, if y'all sleep in separate rooms, or maybe somebody, take a chill pill and sleep on the couch tonight.
Right, yeah, he
which
won't do that. He told me not to
Okay.
talk to him.
All right,
so
well.
I want to get my daughter out of the
Okay.
bugs and eat, if that's okay. And I have a
I'm
4-year-old.
perfectly fine with that. But I mean, like I said, it's just something that we got to You know, I mean, if bringing your daughter inside means he gets to come inside too, that might be something where we got to say, look, let's make a compromise. If you want to come inside with her, that's fine. I'm going to go to the room, and I'm going to close the door, and I'm going to stay in here, but at least, you know, your daughter's safe, and she's not, you know, out here in the road or whatever, or in the heat, you know, getting bug bites or something like that. Does that make sense?
Yeah, so I'm gonna grab her.
Okay. Let me just get some information from you real quick. What's the kids' names?
Kylie,
Is it K-Y?
K-Y-L-I-E is my 12-year-old.
K-Y-L-I-E.
Kylie
Okay.
Kuhn. I'm sorry, I really have to go back in because my 4-year-old. Can I just?
Okay,
get
yeah,
her?
absolutely. Well, if he's going to wait out here for just a second with her, and I'll go inside if you want with you. And
I don't trust him alone with her.
okay, well, then we can all walk back inside.
Okay.
All right.
I don't want that either.
Okay, well, I mean, that's what I'm saying.
Okay, so
But we need to check on the 4-year-old. We want to make sure the 4-year-old.
No, that's fine. My 12-year-old's in there. So.
Okay, all right. So what's Kylie's last name?
Kuhn, K-U-H-N.
K-U-H-N. What's the middle name?
Should have one.
You should have one. Okay, what's her date of birth?
May 22nd.
Okay.
Yeah, he called you, so can you get the information from him?
Yeah, that's fine. I mean, are you not wanting to, I'm just trying to get names of the kids.
Yeah, no, I gave them to the people earlier.
Okay. All right, well, I mean,
She's
I'm...
not answering.
So I wanted you to see that longer clip because it's indicative of her state of mind and attitude during this whole thing. Again, she's complaining about that he won't talk to her. And then Deputy Lynn, bless him, is trying to propose solutions, compromises, ways to resolve the situation for the betterment of the children. And she is just not interested in any of that. She has no interest in that. And her entire demeanor is just sort of argumentative and combative. Now, if she's that way with a deputy, standing there in uniform, what's she going to be like with her husband? I mean, are you surprised that he keeps telling her, I don't want to talk to you? I mean, can you blame the guy? She is just clearly increasingly frustrated with the whole thing because she's not getting her way. I said, she's not interested in a compromise. She wants her way. She wants those kids. She wants him gone. And she's going to see to that. Meanwhile, in the background, you've got Collin just walking around laughing and playing with Laney. Does he seem aggravated or frustrated? I mean, he literally said, I'm happy that I'm locked out here in the driveway because I'm away from her. This is the situation 45 minutes for the murder. This is what's building and what's leading up to it. Ultimately, Deputy Lynn gets her to agree to let him inside with the child. She then locks him out in the garage. And Collin texts Hardy at 6:13 that he is locked in the garage. And you saw the text messages between Mr. Joyner and Mr. Turner. And Collin saying, she's crazy as hell. And at 6:13 he says, she locked me in the garage. Why? Why does he say? He says, she just locked me in the garage because I wouldn't talk to her. Which, as you've seen, is the thing she keeps complaining about. He won't talk to me, he won't talk to me, he won't talk to me. So then she locks him out in the garage. That's 9 minutes before he calls 911. 6:22, Collin calls 911. You've heard that call? He, on that phone call, is the same way he is at all of the times during that day. Whether he's on with 911, whether he's talking to the deputies, whether he's being secretly recorded, he's calm, he's rational, he's explaining what's going on. I mean, if anything, he just sounds a little disheartened. And he's relaying to them what's happened. She's locked me out in the garage. You guys have been out here twice today already. And she comes out there and shoots him. And it's so out of place and so shocking and with no context that you heard the surprise of the 911 operator who asks, what was that? Because there was absolutely no context. You know, I mean, she works for 911. She probably hears a lot on 911 calls. You know, people fighting, screaming, yelling, gunshots. But here there was nothing, absolutely nothing, until he got shot in the back. This is State's Exhibit 12. You can see that door to the garage leading out. And you can see the little Yeti cooler, probably, 8 feet from the door, and where Collin was found. Not in the doorway, not by the door. He's well into the garage. What does Ms. Kuhn say about it?
Just for right now, okay? Just for your safety, for ours, okay?
I'm a murderer.
So listen, listen to me. You're not under arrest right now. You're being detained, okay? We'll investigate.
No, you should arrest me. I killed my husband. Hopefully I just shot him. Maybe he's not dead. He should not be dead.
She says 2 things there that are supported by all the evidence. 1, a murder. 2, he should not be dead. Absolutely. So let's talk about the injuries that Collin suffered. Gunshot wound to the upper back, comes out of his neck, ends up lodged in his wrist. Breaks his ribs, but this one goes through the trapezius muscles, the cervical vertebrae. Now, obviously we weren't there, we didn't see it. Logical conclusion is that he's either holding the phone or is like this as the bullet comes in the back, out the neck, and ends up into his wrist. Shot in the back, back to front. Second gunshot, again in the upper back, goes through his ring, ribs, lungs, back to front, comes out through the chest. Third gunshot in the right of his back, again goes through his right ribs, lung, sternum, exits his chest. Fourth gunshot, then the left lower back, goes through his spleen, goes through his heart, and is ultimately recovered. You heard Dr. Oleski's testimony about these injuries, about how each one, likely in and of itself, would have been a fatal gunshot wound. And what does that tell you? These were kill shots. We talked about premeditation, the circumstances of the killing. What was her intent? How do we know what her intent was? These gunshots tell you her intent. 4 kill shots right to the back. Her intent was very clear. Now you have the pictures, of the autopsy pictures, which I'm not going to put up here, but if you have questions or want to look at them, they're all in evidence. You will see those wounds on his back that the doctor described. They are perfect little circles. I always think sometimes they almost look like cigarette burns, just perfect little circles, look almost harmless sometimes. Those are entrance wounds. Exit wounds he has on his chest, much larger, much more ragged as the bullet comes out. Those are very, very clear. I said, if you have any questions or as to what that evidence shows you, I would urge you to look at those autopsy photos. And you would clearly see the difference between entrance wounds and exit wounds. It's night and day. Plus the fact that he's got 4 holes in his back and 2 in his chest. He was shot 4 times in the back. That's what that physical evidence shows. It's very clear. So Ms. Kuhn is taken to the station, interviewed by Detectives Rowell and Kelly. Again, that's a fairly long interview. If you want to watch it again, you can. But I did want to just highlight some of the things that she talked about.
After they left, when I know I called my mom. He was in the garage again, and I locked him out. I locked it for some reason. I think to talk to him.
You locked him out for some reason, and that was the talk?
I locked him out. He was in the garage. I locked him out.
Okay.
But he didn't. He was still in the garage. opening the door to talk to him. And, he tried coming in, so I blocked the door, and he kicked my foot, and was trying to push to go to the door. And I was trying to keep him out. I don't. And then I shot him.
So her version is she locked him out, she went to the door to talk to him, and he tried coming inside, and then was kicking her foot, so she shot him. Now again, you should be thinking to yourself, I've seen the physical evidence, I've heard the 911 call. That is not what happened. That's clear. But also, even if her version there is true, right, let's ignore the physical evidence for a minute, let's ignore the 911 call. Let's just say that version is true. She opens the door, he kicks her foot, she's trying to block him as he comes in. That's still murder. I read to you the self-defense instruction, imminent danger of death or great bodily harm. Kicking somebody in the foot doesn't mean you get to shoot them 4 times. And that's, I said, let's just pretend for a moment all of that was accurate. It's still not self-defense. That's her story. Now, you may ask yourself, why is she telling this story? And the logical conclusion that comes to mind is that she never realized he was on the phone with 911. Right? She opens that door, fires that first shot, and ultimately the phone was found sort of underneath him. She didn't know he was on the phone with 911. And she never realized the difference when he said, she just shot me. He didn't say, you just shot me. It didn't occur to her the difference. She didn't know he was on the phone with 911. So she's telling the detectives this, thinking, hey, there's no other witness besides my brother. And this is what happened. She continues.
He was still coming towards me. I don't think I shut the door, and I went. To get my kids, and I took them out of the house.
She is insisting after she shot him, he is still coming towards her. That's just not what the physical evidence shows. But that's her version. He's still coming towards me, even after I shot him, so I had to shut the door and get in the house to get away from him. That's not what the evidence shows. She continues.
Sure. So just to kind of...
I didn't mean to shoot him. It was at least twice. I didn't mean to shoot him, but I did. And he said something, and just the look on his face.
What was the look on his face?
He was gonna kill me. And that's how I shot him.
Okay.
So, good bit to unpack in that statement there. She says, I didn't mean to shoot him. Okay. She wasn't cleaning the gun and it went off. Okay. She went to the door, shot him 4 times in the back. She's telling the police, I didn't mean to shoot him. You absolutely meant to shoot him and kill him. No matter how you try and describe it, that is crystal clear. I didn't mean to shoot him. Yeah, you did. And then she says, he said something and had this look on his face. He was going to kill me. That sounds good. Right? It sounds like self-defense. He was going to kill me. Well, you know what he was saying because you've heard it. He was speaking calmly in a rational manner. She is sitting there telling he was going to kill me. No, he wasn't. But again, she doesn't know he was on the phone. So in her mind, How would you disprove? And you think about this for a moment. And again, she may not, have not been aware of, forensic pathology, and I don't know how well that's commonly known. So let's ignore forensic pathology for a moment and consider her version here if Collin was not on the phone with 911. Could this version be disproved? Right? She's saying he's coming at me, he's gonna kill me, he's kicking me. Right? This is probably what we'd be left with. Luckily, Collin called 911. Unfortunately, Collin did not call 911 in time to save his own life. But him calling 911 hopefully will ensure that his murderer does not get away with it. She didn't know all that.
Why did you have the gun when you went to the garage door? Do you know?
I just wanted them to go.
Detective Rell asks her, why did you go to the door with the gun? The answer is because she wanted to kill her husband. That's clear. She tells him, I just wanted to go. He's locked outside. You're in the house. Okay, that's the opposite of I just wanted to go. That's, I'm going to go kill my husband. But she is sitting there saying, I just wanted to go. This is what she's telling the police. No, she had plenty of options. Now, again, she doesn't have a duty to retreat. She's not legally obligated to leave the house. But she's saying, I just wanted to go. No, you just wanted to go kill your husband. That's what she wanted.
I couldn't get in the front door because I had taken out the batteries from earlier.
The front door was locked. Collin couldn't get in the house. He was locked out. She couldn't even get back in the front door.
The jail, they don't.
Hey, Bree, where were your babies at when this went down?
They were in my room.
They were in your room? Okay. Do they normally hang out in there, or did you tell them to go to your room?
I don't know.
You're not sure? Okay. You've got two small ones, and then you have a 12-year-old girl. Okay. Where was your 12-year-old at?
With them.
They were with them in your room?
Yeah.
Okay. Was he on the...
All the children are in her room. And again, we talk about premeditation, talk about the circumstances behind the killing. All the children are in her room. Her gun is kept in her closet. So again, whether it's 1 minute, 10 minutes, kids are in her room. Clearly, she goes to her room, retrieves the firearm, goes back to the door to kill Collin. That is premeditation. Judge, if you could blank the screen. Now that interview continues, and again, I'm not going to sit here and play the whole thing. You can watch it if you want, because the detectives continue, and they keep asking her very pertinent questions. What was he doing when you opened the door? Where was he standing? Did he have anything in his hands? And every time, she simply avoided the question. I mean, they must have asked her 5 times. Every time, she answers but says something like, oh, I just tried to help him, or there was so much blood. She does not want to answer those questions. And again, we know why, because we know what Collin was doing when she opened the door. She doesn't want to answer those questions. She doesn't have an answer for those questions. Your job now is to evaluate all the evidence you've seen and heard. And I hope you'll see that it's very clear what happened. She's getting increasingly frustrated throughout the course of the day. She's not getting her way. Collin is he doesn't want to talk to her. She knows he wants to take those kids. She knows he's going to win the custody battle. Now, again, premeditation does not mean a logical, calm decision, because obviously killing your husband to gain custody of your children is not a good plan. So premeditation is not planning or a calm, logical decision. It's just intent with time for reflection. The evidence shows, again, we'll never know exactly how much time. She locked him out, went and got her gun, went to the door, came back, and shot him in the back 4 times. That's the evidence. And that is premeditated murder. Thank you.
If the attorneys will approach. Okay, members of the jury, we're going to take a brief recess. We'll try to be back here in court in about 10 minutes. Please not discuss the case among yourselves. Leave your notepads and papers underneath your seats, and we'll be back with you momentarily.
Please rise for the jury.
All right, we'll be in recess for 10 minutes.
Remain standing for the judge, please.
All right, and Mr. Barnes, are you ready?
Yes, sir.
All right, let's bring the jury back in.
All rise for the jury, please.
All right, everybody can be seated. Mr. Barnes, you ready to give your closing?
Yes, sir. May it please the court, Mr. Alderman. Well, good morning, ladies and gentlemen. Again, I'm James Barnes. Didn't have a whole lot of work in the trial, and then the division of labor was certainly askew. That happens. It's a fluid event. I thought I'd get up to bat more. This is my 134th criminal trial, and I'm going to make an admission to you. I'm nervous. I'm nervous. I'm nervous because I don't know if I'm going to be able to get everything out. And I'm nervous because 3 years ago, Bree Kuhn and her family picked me. Mr. Etheridge came on the case later, but they picked me. And we all know that the woods are full of lawyers. And, you know, as you work up to this event, I go back to, you know, what I told them, what my promise was. And my promise was that I would follow my oath, that I would do everything I could for her. And, you know, you worry that when you get here, sometimes the closings come out the way you want them, sometimes they don't. They're a little bit like snowflakes. They're all different. But then, when I was thinking about my oath, I realized that, well, this buggy has a lot of seats in it. Because you guys took an oath. And you're going to follow your oath. You know, it's interesting. You come in on Monday to jury selection and ask you to stand up and, you know, you take the oath. And I'm sure there's not much, you know, reflection about that. It's like, you know, now I stand up and then you come in here and you take the oath when they swear you in, or when the judge swears you in. But you took an oath. You took an oath. You probably didn't even know the words in that oath. But you took an oath to try this case fairly, and to keep an open mind, and to look at all the evidence, and to try this case against the backdrop of reasonable doubt and presumption of innocence. All criminal cases throughout the country are about one thing: people will say, what's this case about? My wife will say, tell me what's this case about that you have? It's all about the same thing. It's all about whether or not the state can prove the allegations. Now, as it turned out, the last witness that we heard in this case was Mr. Alderman. He, and I'll get into this later, but he took some liberties, looked at the evidence, made some statements. They're not facts. They're not facts. It's you guys that I care about, okay? It's you guys. The other thing in this case that had me concerned, more nervous probably than I usually am, is that we started the case with a bang, I guess pun intended. Very, very powerful stuff, right? You agreed, keep an open mind, presumption of innocence, reasonable doubt. And then you hear the 911 call. And, I've listened to it, I don't know, a dozen times or so probably over the last 3 years. And that first shot, it gets you. I kind of jump every time. And I looked over at everybody. People's look, well, it ranges, of course, but it was like, wow. It was like almost, like, what are we doing here, right? What are we doing here? And I realized at that point in time that presumption of innocence and reasonable doubt, they had left the courtroom. Those two were somewhere else. And that's okay. That's okay. Because when you hear that as a human being, and you've never heard anything like that before, it's okay. But you have to come back to reasonable doubt and presumption of innocence ultimately. And I'm confident, again, when I reflected on your oath, and we picked you guys, right? It was a vetting, right? Took a while. And I said, okay. There's going to be, the sympathy factor, and the judge is going to tell you that there's no place for that here. There's no place for that here. We ask you to bring in your common sense, but we tell you to leave your emotions at the door. It's kind of a strange parlor trick, I suppose. The thing with this case, to me, was always the why, right? Why did it happen? Why did it happen? And Mr. Alderman, I can hear him now. He's going to say, I don't have to prove why did this happen. I guess he has a version of that, including, tales of Bree Kuhn hitting herself, and all sorts of things that we'll get into here, in a little bit. You're going to hear a lot about reasonable doubt. As I go through, and ultimately as you go through the evidence, you look for the three areas, right? You know what they are. Where does reasonable doubt come from? It comes from a lack of evidence. Let me give you an example. I mean, it was a lot of lack of evidence, but how about the camera, the body cam that the guys had when they went up to Pennsylvania?
You want to maybe object and approach? Or I'm going to object and maybe approach?
You may.
here's the thing. Lack of evidence, and we're going to go through some of this, okay? Conflict in the evidence itself. That's where you get the reasonable doubt from. All right. The state must prove this case a couple of keys. Premeditation. There is no witness, no evidence of premeditation. None. I mean, he's got a great, tale, I suppose. But Bree Kuhn is supposed to put her kids here, and I'm going to get my gun, and I'm going to walk into the garage, and I don't know that he's on with 911, but what difference would it make who he's on with? It makes it a little interesting, obviously, that he's on with 911, but if he's on the phone, that's a witness anyway. I mean, if it's premeditated, wouldn't she wait? I mean, you do it a different way. You just don't go in and, I'm going to do it this way, right? If that's this is her scheme, right? This is her, her plan. It makes no sense. There isn't any evidence of that. You can tell afterwards. She's in shock. Everyone says she's in shock. Anybody that came in touch with her, she's in shock. You can tell she's in shock. You're not in shock if you deliberately, intentionally, and more importantly, planned to kill somebody. You're in shock if you run somebody over in the road and you're surprised. That's the shock. Man, she must be the greatest actor in the world because, sorry, I'm battling a cold too. 1 minute, she's this, I'm going to plan it out. I'm going to put the kids here. I'm going to go get my gun. I'm just going to go in and shoot them. And then the next minute, she's saying, why isn't somebody, an ambulance, is he dead? It's kind of what happened. And then, it's flashing out, right, if he's dead, I'm a murderer. And it's all haywire up there, right? If this is premeditated, I mean, she's going to shoot him. She's going to have a different demeanor. What happened after the shots? What did she do? She gets her kids. This is all about her kids. You know how many times she said kids in this trial? In this, trial, through the evidence, if you listen to all the body cams and so forth? 70 times. 70 times. This entire case is about her protection of her children. The number one instinct that human beings have, mother protecting kids. Number one. Okay. Sorry, I've got some notes here, obviously. All right, let's kind of walk through it all. Right? Walk through it all. Let's get to know these two. First, let's take us to Key Largo. The couple goes to Key Largo. Now, it's interesting that the brother has to come along. He said, yeah, they kind of wanted me there to temper anything. All right. So there's, friction. And what do we learn from that? We learn that Collin says we're both psychopaths and narcissists. Right? So keep that in the back of your mind. Additionally, he has 100% disability from brain injury. Keep that in the back of your mind. Now, let's move then to get to know Collin a little better with this suicide attempt. There's no contradiction to this evidence. Eric Kuhn realizes that his sister has taken a bottle full of pills, drank a significant amount of wine. He calls down to Collin, right? This is how much Collin cares for this woman. Well, what in the world is he doing? He knows she's upstairs, had just taken the pills and the wine, and Eric says, hey, you called EMS, right? No. What? And then we're supposed to believe that this guy is a good husband and it's all her. That's crazy. If that call didn't exist between those guys, and if this suicide didn't happen and it's all just made up, Mr. Alderman would be giving you proof of that. Now let's talk about Eric Kuhn. Do you think for a minute, if his testimony, because we're going to talk about his testimony here in a little bit coming up, and I've already referenced him a couple times, and some of you might be thinking, well, how is he such a great historian? Do you think for a minute if he was going to fly in here, right, and we brought him here, state didn't, kind of important. He's the only, I guess other than the 911 caller, but he's the only other witness. You would think that if it's all orchestrated, man, we'd have had it down, right? We'd have had it tight. He's doing the best he can. Do you think that he would have said, no, that, I realized then that, my sister kind of laughed and said that she was a psychopath too. I mean, right? It would have been, we would have gotten a lot more out of that. But it was important for him to talk to you because clearly when you go back and you listen, there's a struggle going on there. The guy's doing the best he can. His sister ends up getting arrested. And we want to browbeat him over some choice of words that really, okay. The point of all of that is he heard what he heard and he did his best to describe it. But he's not watching it. He's not seeing it. So no, you don't just reject his testimony because he gets some words wrong that really, I mean, no one's in here. I mean, we're not in here saying that Collin was trying to kidnap, his kids or kidnap, his stepdaughter. So what is that? What does any of that matter, right? What does any of that matter? All right. We've got apparently a woman who diabolically, right, planned this crime, right? She's got suicide attempts, 2 Baker Acts, hospitalizations. She's doing the best she can, but she's got some issues. She's not scheming this whole thing, right? She's not, here's what I'm going to do. I'm going to first call the police, and then this is going to happen, and that's going to happen, and then ultimately I'm just going to go in and shoot him. That makes no sense. Obviously, the white elephant in the room, and why we're here to a large degree in terms of the why, the police. Okay, the police. She cries out for help to them. She's relying on them. She's raped, and for anybody that thinks a husband can't rape his own wife, well, you can go back to about 1950, right? With those kinds of thoughts. Obviously, that can happen. And she calls the police. She's had enough. She gets thrown around, thrown on the ground, and she makes the call. They get there, and it's really kind of just a checklist deal that they go through. And while, you got the kids running everywhere, too, which is odd, right? She's given her, she's telling the cop that she was battered. And he's saying, you have to have signs of the injury, and this is Hartbarger, obviously. You have to have signs of the injury. Can't do anything about that. She says, while her kids are there, right? So she can't really get into too much detail, but so she says, was also raped. I don't know. Had he already made up his mind? Was it just going to come in here and I'm going to checklist thing and I'm going to head out? If he had heard that, well, there'd be a rape kit. There'd be action taken. At least the two would have been separated. No, nothing. And conveniently, well, I didn't hear her. All right, well, that's too bad, right? That's too bad, because we rely on the police. She was relying on the police. They turned her back on her right from the jump. Now, in terms of the sequence, we didn't see the body cam of Quick until yesterday, and that's fine. But that one is interesting, and they say the devil is in the details. When Quick is talking to Collin, he's explaining to him why people can't go to jail. They're not going to take anybody to jail. You have to have marks and so on. And he says, one of you is going to have to snap first. Wow. Okay. One of you is going to have to snap first. Is that what? Meanwhile, we've got Bree inside saying, I guess he's just going to have to, I'm going to have to let him punch me in the face, I suppose. I'm going to have to give in to his aggressions. Do you think that this situation where the police go, the testimony, the evidence is 5 times in total, do you think that this situation is harmony? It's pretty reasonable to think that there's some physical going on, right? Anyway, back to Quick and Collin. Someone's going to have to snap. But you know what is interesting, and I didn't catch this until, I don't know, believe it or not, a couple days ago. So you've had this thing for 3 years. You prepare in earnest when you get closer to a trial, obviously. When Collin is, again, talking to Quick, Quick says, again, we're going to have to see some objective sign of injury, kind of the same thing that's, going on with Hartbarger inside. Look for it. Watch it again. Collin pauses, and you can see the wheels turning. He's like, maybe, actually says, maybe it's worth doing that. Maybe it's worth doing that. And so now what does he have? He's got, someone's going to have to snap, and his wheels are spinning. Okay, I see now how I've got to play this thing out. Now, another key point is when the police get there, Collin's sitting out front. I mean, he's waiting for this. Thank you for showing up so quickly. My man, she called the police on you. Quick says to him, tell me what's up. Well, first he says, do you want like my, he had two versions, right? Do you want my line by line, or do you want my summary? I mean, he's ready to go. He starts off with, she's tried to commit suicide, she's crazy, she's been Baker acted, and I don't know, there's a minute or two where Quick is like, all right, man, I get it, but tell me what happened to cause her to call today. So Collin wants to deliver that. That's not the most interesting part of all this. The most interesting part of all this is I've never heard of this. Collin realizes the police are coming, right? So he's poised, he's ready to go, he's going to report all the problems. She's the mental health victim. He changes his clothes. All right. Odd in and of itself. But when he talks about it, he says, yeah, I got into some shorts that don't have any pockets. And right after that, I put my gun in my car. What does that tell us? What's that tell you? He walks around the house strapped, man. He walks around the house armed.
I'm going to object.
Overruled for now.
Go back and watch it. Go back and watch it. Pockets. Now I don't have any pockets. I put my gun. Why would you be? If your gun is in a safe place where it should be, why in the world would you be putting it in your car? Where? We'll add that the kids end up in. Right? This whole thing is about her trying to protect her kids. And we've got him taking this gun, putting it on the dashboard, and the kids end up in there. What? But we're supposed to just believe everything, that we can through Collin. Which, by the way, I might get back into this later. When he calls the police, the final time, he says, she tried to break my arm. Okay. There's zero evidence of that, number one. Number two, if Bree has made this whole thing, up, I guess at one point she's hitting herself. But you don't see any marks on her. I mean, she's going to hit herself. She's going to go to that much trouble. And it just, it doesn't add up, right? She's going to go to that much trouble of hitting herself, but then shoot him. It's a train wreck, man. It's a train wreck. I'm going to get back into that. I'm going to get back into that later on. But where I am now is, why is he calling 911? Because he's locked in his garage? This guy's a Marine. Dude, you're locked in your own garage? I guess, the other Marines would probably have some fun with that. You can't get through the door in your house? And by the way, locked in the garage, devil's in the details. When you listen to this, he's locked in the garage, it always turns into he's locked out of the house. She takes the batteries out of the front door, but it's a modern home. You push the button, you get out. And she opened the door. All right. Back to why is Collin calling the police? Well, she tried to break my arm. Okay. Where along the line did that happen? I guess Bree's hitting herself, but she's not physical with Collin. We have no idea. We have no idea what in the world is going on moments before this call that apparently she conveniently doesn't know that he's on the phone. We have no idea, right? We've got the brother trying to do the best he can. Obviously, you can hear. But what's he said, right? What's he said? Now, if you go back to, he's thinking, I see now what I have to do. If we're gonna talk about, take some liberties, the whole scheme that Mr. Alderman went through, that whole scheme. How about he's calling 911? Why? Because he wants to call 911, be the guy that made the call, because it's about to go down. It's about to go down. What other reason is he calling 911? For this arm that there's zero evidence of? Bree knows it's about to go down. She says later he gives a look. Yeah, she's seen that look before. She knows that look. What do you think's going to happen after he hangs up that phone? Well, she knew. I mean, it's on now. Look, he's got it set up, right? He called 911. Something goes down. She's the mental patient. There's evidence that he calls 911. That works, right? It's not. You got to get past this whole thing. To convict her, you got to answer that question. Why is he calling? Why is he calling?
Your Honor, I object. This is a misstatement of the law.
I'll sustain the objection as phrased.
Here's the thing. Again, Mr. Alderman's going to say, all I have to do is hit these points, right? It's real simple, right? The example was the cake, I think. I'm sure he's like, the egg, the flour, the milk, that's what you need to make a cake. There's 3 things. And these are the things that I need. Well, can we please ask if the egg's really an egg? If the milk's expired? I mean, can we get behind the evidence a little bit? All right. I know I'm jumping around. I don't mean to be necessarily doing that. Okay. Obviously, I've said some things. All right. What do we know about the night before? Because it all matters. Collin is so concerned that Bree is going to hurt the kids, or Collin doesn't. He's going to take these kids. And by the way, this is why I'm jumping around, because I digress. Shouldn't do that. But by the way, is it lost on anybody that what the Marines do? They extract people. Bad guys. Right? We all know this. If he wants to take the kids, take the darn kids. Take the kids. No, he's not interested in that. Wants to hang out, man. Wants to hang out in this harmonious situation. Cop said, if you want to take them, take them. The Marine who's locked in his own garage and he can't seem to extract a couple little kids. Anyway, the night before. Bree is asleep, snoring. Now, Collin, again, where do we get all this from? We get it from Collin talking to Quick. And you can go back and look at it, but at first, Collin says, yeah, it was physical last night. It got physical. I went in to the bed. Bree is snoring. I think it's around 2 a.m. She has, her arm around one of the kids. And he's so concerned, I guess, that this snoring person with her arm around her child is going to hurt the child. Takes the kid, you come with me, you're going to sleep on the couch. Also, they get into this major fight because the volume's too high. I mean, in the world's going on? Just go in another room. Go read a book. I mean, she had the volume too high. And what I'm going to do, I'm going to cut off the Wi-Fi. You see, you get the theme. You get the theme. It's continued torment, indominance. I try to commit suicide. You didn't even call EMS. It's this cycle. This cycle. The battered wife. She.
You want to maybe approach?
Go back. Okay.
Yep, briefly. You want to withdraw the objection?
Okay. I think you get the idea. Building. And until, somebody snaps. It's like that director, I forget his name. He shows you bits and pieces of the movie and moves around. Not the best way to deliver it, but. Well, now let's get back to the failure of the police to protect this woman. We have Deputy Lynn, who comes back, and he's the, let me just cast my hand over these troubled waters. You two really just need to get along. Just get along. You'd think that in today's society, computerized and all, that before going to this place, he would, he'd look and see, have we been here before? And he'd pull it up, and he would have some knowledge of it. There'd be, it'd be comprehensive. Right? No. He shows up. He doesn't know what happened. Doesn't know what happened before. Now this time, Collin's the one who calls. Why does he call? He wants to get another call in, right? Ultimately, this is going to come to a head, man. And he wants his calls in. And his call this time. Oddly enough, I'm out here in the street. Can she keep me locked out of my own home? Are you kidding me? Are you kidding me? Imagine if the answer's, well, yeah, if you're out and she's in there, the law is that you're done, man. It could be a day, it could be a week. Game over. What? I mean, who does that? People that want to kind of give a blow by blow what's going on, right? So we got Lynn there. He's talking to Collin. Possession's 9. It's actually 9 points of the law. I don't think most people know that, but it's not 9/10, but what difference does that make? He's telling him, take the kids. Take the kids is not, not possession's 9/10. You can break the window and go in. At the same time, he's like, listen, everybody's just got to get along. Well, he goes to talk to Bree, and he delivers the same kind of spirit of everybody just got to get along. I mean, wouldn't that be great, right? We didn't call the police, and we didn't call for a priest or a counselor. Anyhow, he goes to Bree and he says, "Man, you just need to talk. You can get along." Well, and then she keeps saying he won't talk to me. I mean, is that the motive here for this whole deal? That she's so worked up that he won't talk to her. And I kind of lost track in the beginning of Mr. Alderman's deal. I don't know if he was trying to say that that Collin was willing to talk or not willing to talk, but you can hear on the video where she's saying, yeah, can we talk? Can we talk? I mean, that's a woman who the next day is going to premeditated murder. Anyway, I'm a jumper, right? I'm a jumper. But Lynn's talking to her, and you just need to work it out. How in the world can you work it out? He won't talk to me. But somehow, in this murder trial, that's where the state is. And for those who think that, man, this is easy, what are we doing here? We listen to the bangs. She shot him. She said she shot him. She said she was a murderer. So it's over, right? What are you doing here? No, man. No. You're going to follow your oath. You're going to go behind the evidence. You're going to wonder, why are we talking about this? I guess it's a motive. What? And again, small detail, but an interesting one, under the theme of the police don't do anything to help her, right? I get the argument, right? I get the argument. Well, the police didn't shoot him. No, man. It's all this torment leads her to call. Who in the world is going to say they were raped? If it's just all, just I get them out of here kind of thing. It's all building up. And Lynn, this is a good one. This is a good one. Lynn says, if you need anything, just call us. She gives a little bit of a laugh. And I do too. Oh, I'll be sure to do that. Hell, I've called you. I've told you. You haven't done anything. Came down and you let my kid go look at your car. That's a nice enough thing to do. Nice guy. Nice guy. But do your job, man. Before I forget, of course, Lynn comes back after the shooting, right? And, it's his body cam that we're seeing, when Bree's like catatonic. Bravo, bravo, good job. I'm going to win this case. We're going to send you to Hollywood. And talk about Florida. Lynn says to her, okay, Rebecca. He didn't even get her name right. I can hear Mark now. Come on. What does that have to do with it? I'll tell you. Because it shows an absolute and utter indifference in the way she was treated. Rebecca. He doesn't even call her Brenda, right? Bonnie. He didn't even get the B right. I don't know. You know, here's the thing. As a lawyer, you know, you're defending somebody in a murder case. You may say, man, what does that have to do with anything? I mean, you're just nitpicky, man. You're just nitpicky. That's part of my oath to bring that up. So I apologize to anybody that just, you know, kind of wants to get out of here. And I pray that you're not there. All right. With Lynn, you know, she says, I locked him out because I didn't want to have this argument in front of the kids. Now, for anybody that thinks that, you know, Bree is at a point where she thinks that Collin's going to hurt the kids, well, then, you know, I think it'd be fair game to say, well, then you got to take the kids out, right? She's not quite there. Not quite there. Because she brings her daughter out to him. So if anybody thinks that's like an aha, no, I mean, she's trying to function, right? She's trying to function. She's trying to have some interaction with her father. I mean, it hasn't reached quite the boiling point yet. All right. A lot of this I've covered, and I apologize to be so note-bound. Normally I'm not. All right, a lot's been made about, you know, what Bree said afterwards. If any among you don't think that this woman's in shock, then I got a lot of work to do. She's clearly in shock. Clearly. She gathers her kids afterwards. She goes and stands. Remember, this is premeditated. She goes and stands, huddles up, I guess, with the kids. You know, I'm a jumper. After she checks on her husband, that she intentionally reflected is what the element is. Time of reflection. Anyway, after that, she gets the kids, goes over to the neighbor's house. And again, what are the heading of she's not quite right, she's in shock, because, why is that important? Because so much that she said in the interview is now, you know, this beacon of information. And she's standing out there huddled up with the kids at a neighbor's house that she doesn't really even know. They never said they knocked on the door or anything. I mean, she's just standing there. She's white as a ghost. I want to talk about objective signs, right? That's an objective sign of shock, obviously. And what is her concern? What's the theme? The theme is torment. The theme is all she really cares about is her children and their safety. So she says to the different neighbor, I'm not as good with the names as Randy is. Like that old guy that calls his kids by different names. You know, will you take care of my kids? Will you take care of my kids? You know, what's going on there, man? What's going on there? She's the abusive relationship. And he said, well, why didn't she just divorce him? No. Whether he gets, I mean, all right, what? She's not going to get custody, and she said something about, you know, he said to her, no one's going to believe you, you're a crazy bitch, and you're not going to get custody and stuff. Well, she sure got custody from Special Agent Hardy, right? Anyway. The theme is the torment. The theme is that this woman really just cares about her kids, this diabolical killer who says 70 times, kids, kids, kids. And then, you know, she's at the car, and what she says there is being used against her. She's, I mean, can you imagine, right? Can you imagine? Whoa, why isn't there an ambulance here? Why don't you guys get the check on him? This person that intentionally killed her husband. But aha, she says she's a murderer. There you go. That's an admission. Let's wrap it up. Let's go. You know, I don't know which officer it was. Probably would forget her name anyway. But she says, look, don't say anything right now. Don't say anything right now. Why? Well, maybe she hasn't read her Miranda rights by then, but man, please love when suspect. When people talk, right? I love it. But finally, there's a drip of compassion in the female officer. Female, kind of fits. Just don't say anything. Haven't seen it in 35 years. Good for you. A little late, but good for you. Well, where are we, right? We're in the area now of he's in shock. So when she goes to the interview, you know, I don't know, maybe it's me, but that, get this, it's not, I hate to tell people that they didn't do a good job in their profession that I'm not even in, but really, you're going to let this fan blaze the whole time? That's not interviewing 101, right? No. But what has happened in this case is that everything that she has said there is now being, you know, dissected, looked at under a microscope. She said that, so it fits back here, and you know, but the source is that, you know, what she said. Again, she's in shock, right? If somebody took the witness stand and they were in shock, the judge wouldn't even let them. I mean, you know, people, this is a murder case, right? Somebody came in and they were not of the right mind, you know, whatever was going on, they wouldn't be able to testify. But we're looking back at Bree in this interview, and we're picking everything apart. I get it. He's got a hard job. He's a great lawyer. Well, don't let the fact that he's a great lawyer turn into and result that she's this diabolical, murderer. It just doesn't make any sense, right? So you gotta, see, that's the thing as a jury, you gotta, he's trying to sell you a car A, I'm trying to sell you a car B. Obviously, you're gonna, you have to make the choice, but you gotta look at everything, step behind everything, examine everything. Don't just say, well, she said in the interview. There's a time in the interview where you can kind of tell she's in her own world. Yeah, they're asking questions. She's not even addressing the question. Where's her head most of the time? Is he dead? And I guess that's orchestrated. Mr. Alderman will tell us. But you got a genuine concern of, where her kids are. Which dovetails back into the whole theory that the concern is the safety of the children when this guy's, I'm going to suggest to you, I get an objection, walking around, with a pistol. And
Yes,
that,
Your Honor, I am going to object for speculation, or that is, there are facts not in evidence.
well, you want to speak?
I'll overrule.
I mean, I don't know. Go back and, if he gets to put the video up and say, look, well, I do too. Go back and watch that. All right. What else, Well, at least in the video you can say, she's fully cooperative, right? And you would, I think if a person is going to plan a murder like this, while he's on with 911, well, come on. Anyhow, if this person is going to plan that, I don't think they're going to be all, open to talk. But she's doing the best she can. She tells him where the gun is, too, right? This isn't, I don't know. Look, if she planned this, man, it's a train wreck. It's a train wreck. And again, I can hear him. You say, well, she doesn't have to have long to plan it. I don't know. There's no evidence of any premeditation. None. That you will be convinced beyond a reasonable doubt about. Let's bring Mr. Reasonable Doubt back in. Somebody can't maybe be guilty, probably is guilty. Well, I don't know, I think 51 before. No. While I'm on it, reasonable doubt instruction says you have to have an abiding conviction of guilt. When Mr. Alderman flashed that up there, he didn't talk about that, did he? Twice in that instruction, an abiding conviction of guilt. We're talking about ultimately a huge decision. Big time in your life. You've made them. Career, marriage, kids. This isn't a, which soup spoon should I use? There's zero evidence in this case, zero evidence that could convince you beyond a reasonable doubt that this is premeditated. First degree murder? Come on, man. You know better.
Your Honor, I'm going to object.
sustain as to, you know better, I'll strike that.
All right, again. If you get to a place where you want to find value in the interview, well, I mean, I'll spend some time there with you. She says, I tried to block the door. And again, it gets back to, you saw the size of this guy. You see his arms? Tried to block the door. Listen to that audio, man. What in the world's going on? The whole thing's reaching a tipping point, and she's blocking the door, doing the best she can. I guess that's when his arm. I don't. No proof of that either. Anyway, I can't repeat myself too much here. All right, so she mentioned she tried to block the door. Said he was coming towards me. All right. Well, let me tell you how all that works. Mr. Alderman is not a reconstructionist. He's not an expert witness in this area. He's got it all laid out. Got it all laid out. And what I would challenge him on is he flashes up here. First bullet here, second bullet here, third bullet here, fourth bullet here. Oh, really? How do you know which one was the first one? You know where that one went. So that's a flaw. Additionally, he's looked at the entry wounds, and he knows what those are. He knows how it all happened in there. He's your video, and we've got the audio, and let's wrap it up and go. The evidence is, and you don't need to be a reconstructionist for this, that there's a shot. How about being turned, right? Being turned. I mean, he's not like, excuse me, to turn my back. It's not like, there's no evidence he's just here and it's just, right? The state would want you to believe that, he's locked in the garage, grabs the gun, bursts in. So, no evidence of that. No evidence of that. All right. I'm going to have to bring this in for a landing at some point, obviously. The justifiable use of homicide. Self-defense. So stand your ground. Mr. Alderman spent some time on, it has to be an eminent threat. An imminent threat. Well, that's existed for a while, right? I mean, if he's, batters, he makes the call, he's battered me, he's raped me. It's fairly, eminent. Even in her, look, this is back to if you believe, take any value whatsoever, because it's either you do or you don't with the interview. And if you do, he was coming towards me. That's relevant to the self-defense. The struggle, relevant to the self-defense. Defense of others, right? Also includes, the children. She's gotten to a point there that look, again, it's not going to surprise anybody that her concern, is the kids. Let's talk about, I'm going to spend a little bit of time with you on Eric Kuhn again. It's just the dichotomy, that the police, I don't believe you. Good luck. Just talk to him. It'll be fine. And then you have the sophistication of, we're going to send 2 guys to Pennsylvania. We're not going to let them know. Well, really, why is that? Because we want to get, when I get them a little bit off guard. But then, the defense isn't running around with a, little James Bond camera and talking to witnesses, catching them off guard. Then you talk about, fair trial. That's some trickery, man. That's some subterfuge. Where was any of that when they were called to Bree's house? Just look. It's just not right, not fair. Now, I was on the phone. I'm not a witness in this case. I hate to say I in front of a jury, particularly in a case like this. No, it's been brought up. I was on the phone. I said, just walk it through. Just walk it through. Those officers didn't ask him a single question. Not a single question. Fly all the way up there. We're going to do a little, a little tactic, a little trick. We're going to show up at 6 a.m. unannounced. I don't know. I didn't start the whole thing off by, hey, just walk them through. They had no questions. And then the guy comes down here. Oh, he's, how was it? She saved him. He's now saving her. He's going to be the savior. And then he's really, this is kind of baffling. He's ridiculed ultimately. You didn't say this, you didn't say that. I wasn't asked. I was told to walk through it. Was it 3 days after he listens to an event? Probably an event that he's not going to have anything like that the rest of his life. But we're going to use this stuff, man. We're going to use this stuff to convict your sister of first-degree murder. I don't know. I guess I should have spent more time with him. He said, 7 minutes, and then about this phone call. And then I said 45 minutes, and if you go back to the exchange, it's really on me. He was called all day long, right? That's the other thing here. Why is she calling her brother all day long? Again, it's not what you see when the police are there. I mean, this is a day. This is a day. Because he's being called all day long. Anyhow, I just wanted to mention, that was probably more my fault. Okay, let's get to, I think, let me just look. The problem sometimes is, as a lawyer, you come into these and you say, I'm not going to chase rabbits. What that means for lawyers is that when the state goes first, and anything they say, you go after, you take the bait. Sometimes it can look like you're adding credibility to it. But it's hard, right? It's hard. All right. Let's get to the jury instructions. And I apologize. I'm almost out of water, so that's the good news for you. That'll get me to sit down and shut up. Killing with premeditation is killing after consciously deciding to do so. All right? The decision must be present in mind. Present in mind. There's no evidence. There's no evidence of that. Now, fair enough. How can you get into somebody's mind? Well, the way that, the way it's done is if you want to know what was on someone's mind at the time, anytime, what do? What's the only thing you can do? Is you go back before and see if the before is consistent with what you are trying to allege or find out in terms of their mind, and then you go afterwards. I mean, clearly, the law wouldn't be the way it is if there was no way to prove it, right? I guess ultimately, Mr. Alderman's like, well, there's no way to prove that. Well, all right, fine. We'll go on, right? The period of time must be long enough to allow reflection by the defendant. No, I mean, there's no evidence of any of this. Any of this. All right, we get to second degree, right? First degree is the low-hanging fruit. I mean, no evidence, okay? There's no evidence of premeditation. The second degree, is number 2, and you'll have these. Not a PowerPoint guy, I guess I should be, but be stumbling around with that probably. Is done from ill will, hatred, spite, or an evil intent. Back to the cycle that these two were on. What did she say in the interview room? And I don't care if she's in shock or not, frankly. She said about this. She says, "He's my best friend." She tells her father, we had a good weekend. And while I'm on that, I don't know what weekend they're talking about. Right? There's good, there's bad. Where's the ill will, hatred, spite, evil intent? I mean, it's got to be pretty obvious and pretty paramount to get us there. All right, now, this is always tough for lawyers. Where you're going to end up, in my opinion. And look, here's the thing, man. Here's the thing. The jury room, it's like, I don't want to get too weird, but I am a lawyer. Doesn't mean I'm weird by definition. That place it's a place where you can say what you want to say, you can exchange things, and nobody is going to question it. People may have obviously they're going to be, interested, disappointed, or happy, or what have you, but there's not going to be any investigation. You're not going to show any math to anybody. You decide this case on all the evidence, and you apply your common sense. And you're going to get down to manslaughter. Collin Turner is dead. Bree intentionally committed an act or acts that caused the death of Collin Turner. Well, that one doesn't fly either. And again, what are we talking about here? We're talking about, what am I going to say? Beyond a reasonable doubt, right? Beyond a reasonable doubt. Abiding conviction. Well, this love of her life, and I get you, I can hear you. Really? It's the love of her life? Yeah. Yeah. But it's a cycle, right? It's a cycle. And then, why no ambulance for him? Why no ambulance? So I'm not conceding manslaughter, but I would expect that's where you're going to, where you're ultimately going to end up. And if you do, well, you do, but it's absolutely not first-degree murder. Absolutely. It's not second-degree murder. I've already talked about justifiable, use of deadly force. There was a struggle, right? There was a struggle. And again, We don't know. We don't know what's going on in that garage, man. We don't know. All right, there's a couple little ones, and then we're gonna bring it in for a landing. We give you rules of the road in terms of how to evaluate witnesses. And one of those is, did the witness seem to have an interest in the outcome of the case? Well, we've got investigator Rowell, who's still here. He has an interest in this case. So when the government comes up and says, well, the only witness really that would have a paramount interest is going to be Eric Kuhn. Well, I mean, he's sitting back there. I'm not picking on him. God bless him. It's an open courtroom. But he's interested. He's interested. So this whole, they're just doing their job. And however you decide it, they just, okay. No. He's interested. And I'll kind of close. My son, I spoke at his wedding, and kind of, he said, Dad, are you prepared to speak at my wedding? I said, you ought to ask if I'm prepared to stop speaking at your wedding. So I do apologize to some degree for being repetitive, for weaving it through. It's a passionate affair. I get back to my oath and back to the responsibility. At any rate, sympathy, feelings of prejudice. There's no place, right? There's no place. There can't be. There just can't be. In your deliberations in terms of how you get there. I was so in shock from listening to the bullets. I mean, I feel sympathy. No. And listen, this is no celebration of Collin's death, okay? The tragedy, under any circumstances, right? This isn't necessarily Bree versus Collin. We're just going through the facts to determine what? To determine if the state can prove its case beyond and to the exclusion of any reasonable doubt. Now, like it or not, I think I've given all I have. I think I've given it to Bree's family. I think I've given it to Randy, and most importantly, I think I've given it to Bree, and ultimately to you. Wasn't the greatest closing of my life. But it really kind of comes down to, is this woman here a murderer? Or was she a person that was protecting her children and got zero help from the police? And of course, course, ultimately, she was protecting herself, right? Try the case on the facts, the evidence, and you'll get there. You'll get there. You know, if there was any logic to any of this, the not guilty on this verdict form, it should really say not proven. Because that's what it's about. Can the state prove their case? And those are some pretty lofty elements, again, against reasonable doubt, again, with the presumption of innocence. So when you get there, it's all right. Just say, look, man, there wasn't enough evidence for this element or this element. There just wasn't, this wasn't enough to convince me beyond a reasonable doubt. When you look at the whole picture, the whole totality of circumstances, and, in a minute, I'm going to be done, I promise, and Mr. Alderman's going to get up here, and he's going to say some bad things about me. I mean, not like a bad guy, but he's going to tell you that I was trying to sell you a bill of goods. He's going to say some bad things about Bree. And, all I can say is, as I sit there and I hear what he's going to say, and I can't get back up, but you know what? I would if I could. And you know that. This case, it's not an easy case. It's not a she shot him, let's go home, it's got it all figured out. No. On behalf of Mr. Etheridge, and everybody's excited, you can tell the landing gear's coming out, right? On behalf of Mr. Etheridge, family, and ultimately Bree Kuhn, we want to thank you. We do. Taking a week out of your life, that's not easy, right? But I want to thank you in advance for following the law, going behind the evidence, and ultimately reaching a just verdict, given everything, which is justifiably not guilty. Thank you.
Mr. Alderman?
Yes, sir. Ladies and gentlemen, I realize the last thing you probably want to do right now is listen to another attorney. I promise you I'll keep this brief. Mr. Barnes talked about that Collin was walking around strapped. There was zero evidence of that. Okay, this case has nothing to do with Collin's gun. Nobody ever mentioned anything about that. He mentioned several times about shock. She's in shock. She's in shock. Okay, there's physical shock and emotional shock. Emotional shock is somebody threw me a surprise birthday party. I'm shocked. Physical shock is a response to something that has happened. She is not shocked of what happened. She is in physical shock about what has happened. He kept talking about a plan, a plan, a plan, a plan. I hope that every time he said that in your mind, you said, that is not required. Premeditation does not require a plan. The evidence shows this was a premeditated act. Physically, she had to go get her gun, come back, walk to the door with the intent of killing her husband. That's not a plan. but that is premeditation. She went to that door for one purpose, not to talk, not to argue, not to confront him, to kill him. That was her sole intent. Your decision should be based on the evidence. If you have any lingering doubts or questions about what happened to Collin or what took place in that garage, there's a very clear answer.
2 p.m. 45 seconds.
Sheriff's Office emergency. Hi, you guys have been out to my house twice today, and then most recently the deputy talked to my wife into letting me in the house, and then she locked me in the garage, and I tried to break my arm, and I was trying to get back inside.
What's your address, sir?
6184 Jenks, Jenks Drive. She's currently got me locked in the garage because earlier she broke both of the big doors, and then when I came out here to fix it after getting in the house earlier, she locked the door behind me. And then what I said,
What was that?
"You just got me."
She just shot him.
Thank you, Judge. Bree Kuhn murdered her husband, Collin. Now it's time for you to make that official. Found her guilty of first-degree premeditated murder. Thank you.
Members of the jury, in just a few moments, you will be taken to the jury room by the court deputy. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as an email or any other means. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the court deputy. Now, if you need to communicate with me, send a note through the court deputy. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. Now, during the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. All of the exhibits, with the exception of the firearm, the magazine, and the ammunition, will be sent into the jury room with you when you begin to deliberate. If you wish to see the firearm, the magazine, or the ammunition, please request that in writing. Now, in closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. Now I have to do what is one of my more unpleasant tasks to do as a judge, and that is to let you know who the alternates are, because the alternates will not be able to go back and participate in deliberations. The alternates in this case are juror number 94, with the initials of CB, and juror number 58 with the initials of LB. If for the alternate jurors, What I'm going to have you do is go back to the jury room and retrieve any personal belongings. I'm going to have you come back in here. I have a few closing comments to say to you at that time. So if y'all will go with the court deputy, and the court deputy will bring you back in here in just a minute. All the remaining jurors, please remain in your seats. All right, if the attorneys will approach. Okay. The alternate jurors are back in the courtroom. At this time, the remaining members of the jury, you may now take your notes and pens back with you, and you may begin your deliberations. We should have lunch there for you in the jury room now, and it is 12:23 p.m. So you now may begin your deliberations.
Please rise for the jury. Y'all will follow me.
Okay, everybody can be seated. Okay, for the alternate jurors, I want to thank you so much for participating in this case. I don't know whether you're glad, mad, frustrated, angry, disappointed that you don't go back to be a part of the deliberations. But I want to express to you my sincere thanks, the attorney's thanks, for being part of this. having alternates for jury service is vital to our justice system operating. That's because in a case like this, we have to have 12 people. If you get less than 12, then we have to declare a mistrial, and the entire process would have to start over. So that's why we have alternates, because we never want a situation where we do not have enough jurors in a particular case. And in fact, when we started the trial, we actually had 3 alternate jurors. And so we had an issue come up with a juror, but because we had an alternate, then that juror could be excused, and then the alternate takes their place. Now, you may say, well, we were all here. Why did you make me go all week when you had enough people? That's because you never know what may happen during a trial, especially one that goes all week. You may have a juror get sick. You may have a juror have a family member get sick out of town. Somebody has car problems. There can be a whole host of things that might occur, and we just don't want to take that chance. In fact, in my own experience, I've had situations where I've had a juror get sick just before the closing arguments. And had we not had the alternate, then we would have had to start the whole thing over again. I've had another case where after the last witness testified, one of the jurors informed us they had had previous experience and interaction with that witness. It was one of those situations where the witness's name was called at jury selection. They didn't recognize the name, but then when the witness took the witness stand, they recognized the face. And it was the last witness in the case. So again, if we had not had the alternates, we would have wasted an entire day. So I hope you understand why we do these things. But you being an alternate, even being an alternate, I hope this has been a learning experience for you. And I want to thank you so much for your attention. As the judge, not only am I paying attention to what's coming out on the witness stand, I'm paying attention to the attorneys, but I'm also paying attention to the jurors to make sure they are paying attention. I know both of you were. So I want to thank you so much again for your time and attention to this case. So at this time, you do enjoy some special privileges that are enjoyed by jurors, and that is you cannot be compelled to talk about the case whatsoever, and you're not required to talk about discussions about the case. We have recognized for many centuries our society has relied upon juries for consideration of difficult cases, and that anything having to do with this case can remain your private affair. You are now at liberty to speak to anyone about the case, but you are also at liberty not to speak to anyone about this case. That is left up to you individually as jurors. So I also think we do have their lunches, so if you want to grab your lunch, you can do that. You are certainly welcome to stay here at the courthouse and wait for the jury's verdict. Obviously, we don't know when that will be, but you certainly have the right to come back in the courtroom and see what the jury's verdict is, or if you wish, you can leave now. So that's, again, I'm going to leave that up to you. So again, thank you so much for your time and attention to this case. This does count as jury service, so you shouldn't get another summons for at least a year. And with that, make sure you grab all your belongings, and I hope you all have a great weekend. Thank you so much. Oh, I meant to ask, do y'all have any questions at this time? Okay, all right, thank you. Okay, everybody can be seated. Anything else we need to put on the record before we recess?
Not from the stage, Judge.
No, sir.
All right, we'll be in recess until the jury comes back.
Please rise for the judge.
in session.
Everybody be seated. Okay, so they're coming into the building now? Okay. Mr. Etheridge, is Mr. Barnes?
I don't know if he's been notified, Your Honor. I have I'm sorry, I didn't know who to find. No, sir, he's separate from me.
Okay.
I'm sorry, Judge.
Is he like in the building?
He's, I'll go call him right now, Judge.
Okay.
He's close, though. Better be. Excuse me, Your Honor.
Okay.
Mr. Approach, Your Honor.
Sure. Has he come in the building yet? Okay.
Judge, I apologize. I wasn't notified at
All
all.
right. So everybody's now present. So the jurors have come back with 3 questions. Here are the 3 questions. And then I'll read them out, and then we'll go one by one on how y'all want me to address those with the jurors. Number 1, what is the legal definition of depraved? Number 2, was there toxicology on Bree? If so, can we review? Number 3, why wasn't the body cam video of the Pennsylvania interview available for review? If it is, could we please review? Okay, so for number 1, any comments on that, Mr. Alderman?
No, sir. They have the jury instructions. I don't think we can really add to those.
All right.
I would agree, Your Honor.
Okay. So if I say, for question number 1, I tell the jury you must follow the instructions that I've set out before you, is that, or you must follow the jury instructions as they are given?
Yes, sir.
Yes, sir. That's fine.
And I'll note with the word depraved, it is defined. It just is, I mean, depraved mind is defined in the jury instructions.
Yeah.
So I'm just going to say, I'm going to ask you to follow the jury instructions that were submitted to you. Is that all right?
Well, anything's probably going to be all right, Judge, but.
All right. Well, Mr. Barnes, what do you propose I do?
Well, yeah, I would say that the definition is in the jury instructions. Apparently they don't.
Well, they're just asking for the definition of depraved. So I guess when they're saying depraved mind, anyway.
Okay,
I mean,
fair enough.
right. Do you want me to say it's defined?
No, sir, you're fine.
No, Judge, I would just say you have the instructions as I've previously given you.
Okay. All right. I'm going to ask you to read and follow the jury instructions I have given you.
Very good.
Okay. Number 2, was there toxicology on Bree? If so, can we review? My suggestion is that I only have to tell, I should just tell them, you must rely on the evidence that was presented during trial.
Perfect.
Yes, sir.
Okay, so. All right, number 3, why wasn't the body cam video of the Pennsylvania interview available for review? If it is, could we please review?
I would say the same answer.
Okay.
Agreed.
All right, so just say you must rely on the evidence presented. Do you want me to say that I'm not permitted to answer that question? You must rely on the evidence presented during the trial?
I wouldn't even say rely on, just you must make your decision based on the evidence that has been presented.
All right.
I don't think any extra commentary is needed.
Judge, I would prefer what you just said, not permitted. It's almost taken collectively that we're like, hey, you're on your own, you got everything.
Well, I mean, the other one, which I decided when I was going through them and I was just kind of making notes, I mean, the truth of the matter, why wasn't it? Well, neither side admitted it into evidence. But I don't know that I need to tell them that. So.
I don't like that.
Yeah. I'm just going to say you must rely on the evidence that was presented during the trial.
Yes, sir.
And just leave it. I think a lot of these, sometimes the less you say, the better.
Yes, sir.
All right. Any objections to what I'm going to tell the jury?
No, sir.
No, sir, not from the state.
Okay, let's bring the jury in.
Please rise for the jury.
Okay, everybody can be seated. All right, members of the jury, you have submitted 3 questions. I'm just going to go in their order. The first question, what is the legal definition of depraved? I'm going to ask you to read and follow the jury instructions that I have given to you. For number 2, was there toxicology on Bree? If so, can we review? I'm going to answer that by saying you must rely on the evidence that was presented during the trial. Number 3, why wasn't the body cam video of the Pennsylvania interview available for review? If it is, could we please review? Again, I'm going to tell you, you must rely on the evidence presented during the trial. So with that, you may now resume your deliberations.
Everybody be seated. The attorneys will approach All right. We'll be in recess.
Please rise for the judge. Circuit Court's back in session.
All right, everybody can be seated. Okay, looks like we just.
He's been notified, sir. I just got off the phone.
Oh, you just got off the phone with Mr. Barnes? Okay, all right. Sure. Okay. The defendant's in the courtroom. All counsel is in the courtroom. My understanding is the jury has reached a verdict. So let's bring the jury in. Hold up before you do. Let me just say this before the jury comes in. For the people that are in the audience, I'm going to ask that you show no emotion regardless of what the verdict is. If you don't think you can control your emotions, I'm going to ask you to step outside, and then somebody can go outside and tell you the verdict. Also, if you do not heed to these instructions, then you could be held in contempt and face up to 6 months in the county jail. So if you do not believe you can control your emotions, then I'm going to go ahead and ask you to leave the courtroom at this time.
Can I talk to them after the fact without knowledge that warrant being released?
I'm going to give them an instruction on that. Okay. Okay, let's bring the jury in.
Please rise for the jury.
Okay, everybody can be seated. Members of the jury, my understanding is you have reached a verdict. Is that correct? Okay, if you'll hand the verdict form to court security. Madam Clerk, if you will publish the verdict.
State of Florida v. Bree Kuhn, case number 21-CF-1301. Verdict. We, the jury, finds as follows as to the offense charged in the indictment. Guilty of first-degree premeditated murder as charged. So say we all, this 27th day of September 2024. Juror number 109, AD, foreperson.
Do any of the attorneys wish the jurors to be polled?
Nothing to say, Judge.
Yes, Your Honor. All right, Madam Clerk, if you'll poll the jurors, please, by number.
Juror number 185TR, is this your verdict as well as the verdict of the jury as a whole? Yes. Juror number 198IO, is this your verdict as well as the verdict of the jury as a whole? Yes. Juror number 77TS, is this your verdict as well as the verdict of the jury as a whole? Yes. Juror number 263JJ, is this your verdict as well as the verdict of the jury as a whole? Yes. Juror number 112AB, is this your verdict as well as the verdict of the jury as a whole? Yes. Juror number 195EK, is this your verdict as well as the verdict of the jury as a whole? Yes. Juror number 216DJ, is this your verdict as well as the verdict of the jury as a whole? Yes. Juror number 44AK, is this your verdict as well as the verdict of the jury as a whole? Yes. Juror number 267WP, is this your verdict as well as the verdict of the jury as a whole? Yes. Juror number 122JO, is this your verdict as well as the verdict of the jury as a whole? Yes. Juror number 66MS, is this your verdict as well as the verdict of the jury as a whole? Yes. Juror number 109, AD. Is this your verdict as well as the verdict of the jury as a whole? Yes. Thank you.
Ladies and gentlemen of the jury, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations at this time, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be completely up to you to decide whether to preserve your privacy as a juror. With that, again, I thank you for your time and attention to this case. You served a very important function in our judicial system. As I said in jury selection on Monday, there are many countries in the world today that their citizens do not enjoy the right to a jury trial, but we here in America still do, and you were part of that over the course of this week. So with that, again, thank you for your time and attention, and you're now excused.
Please rise for the jury.
Okay, everybody can be seated. All right, is the state ready to proceed with sentencing?
Yes, sir.
Is the defense ready?
Yes,
All right, Mr. Alderman. And if court security, if you could move the lectern back, or were you going to have them go on the witness stand?
It's up to you, Judge, however.
All right, Mr. Alderman, you may proceed.
Ma'am, would you please state your name for the record?
Bree Turner.
And how are you related to Collin?
He's my son.
And you had prepared a statement that you wish to read to the judge, is that correct?
Yes,
Okay, go ahead, ma'am.
Your Honor. This is a letter I never imagined having to write. When I think of the impact the loss of Collin has made on my life, it is difficult to put into words. The grief can wash over at any time. Of course, there are the expected times of grief, such as Mother's Day, his birthday, or the anniversary of his death. There are also unexpected times, like a mother-son dance at a wedding, or when asked how many children I have. There is still a sense of unreality. I can't believe this has happened. I've watched my husband suffer as he misses his son. He is so proud to tell people that Collin was in his last semester of school for his degree in electrical engineering, following in Don's footsteps, and had been accepted into Johns Hopkins for his master's. Collin earned this degree online while being a stay-at-home dad following his retirement from the Marines. Our daughters have had the shock of unexpectedly losing their brother, and as a mother, their pain is my pain. But the greatest impact has been watching how this loss has impacted Collin's younger children, John, JP, and Lainey. We have custody of them and expect to raise them for the rest of our lives. It's been 3 years, and they're still fearful that we will die and leave them once again without parents. They worry that if we bicker, one of us may kill the other. They still ask if we have guns in the house, though they know the answer is no. No matter how many times we remind them that killing a loved one is very rare, their reality tells them differently. We talk about their dad often, but they'll never really know him as they were so young when he was killed, only 3 and 4 years old. And now, not only has Bree Kuhn killed our son, brother, father, but she's done her best to destroy his reputation. I know Collin was not a perfect man. There is no such thing. But he was not the evil man she described. He was a man who loved his wife and tried his hardest to make things work. He loved his children, retiring from the Marines early so he wouldn't miss any part of their young lives. And now he's not there for them at all due to Bree's actions. We believe Bree would do anything to get her way. She killed our son because he wanted custody of the children, and I believe she would kill again. Our hope is that Bree will receive a life sentence without parole. We plan to adopt JP and Laney and give them the security to know they don't need to worry about changing families again. Our faith has carried us along this journey, and we know the Lord will continue to carry us. He is willing that all should repent and be saved from their sins, including Bree. That is also our hope, that she would be made new in Christ and have eternal life with him. Thank you.
Thank you, ma'am.
Any questions, Mr. Etheridge?
No question.
Okay. All right, thank you, ma'am. You may step down. Mr. Alderman, you may proceed.
Sir, would you please state your name for the record?
Donald Turner.
And how are you related to Collin?
I'm his dad.
And you had prepared a statement that you wanted to read to the judge, is that correct?
Yes, sir.
Did you also bring some pictures of Collin that you wanted to show?
Yes, sir.
Okay.
It won't be nearly as polished as my wife. Bree has deprived the world of a loving son, brother, father, grandson, friend, and leader. In the first few days after Collin died, and since then, we have been so blessed with all the people that reached out to us and said how Collin had impacted them in such a positive way. Neighbors, Marine friends, people we had never even met. We saw the love that he gave to the world, and the world desperately needs loving leaders like Collin now more than ever before. We call this God's light in the darkness. The darkness has not won. We know how this movie ends. The light wins. Hallelujah. There's the Marine that never dreamed of going to college, who is now about to complete his engineering degree, all because Collin gave him the confidence that he could do it. There's the Marine that would not accept payment for work on Collin and Bree's house because he was honoring Collin. And there's the Marine that told of a time that he overheard a conversation between Collin and me. We were having a very casual conversation, and the Marine said, "Who are you talking to?" And he said, "That's my dad. He's my best friend." 12 Marines traveled from as far as California to attend Collin's memorial. We were blessed with a son for 33 years, and I know many people are not that fortunate. So many stories of people working with Collin and saying he was the best leader they ever knew. He was only 2 classes away from completing his electrical engineering degree, and I'm happy to say that his school granted his degree posthumously, and I will have that hanging on my wall forever. He had already been accepted into a master's degree program in electrical engineering. And oh, the love that he has for those kids. Kylie, Brody, JP, and Laney are thriving. As the song says, if love is an ocean, they are all drowning. Collin even took on the challenge of homeschooling Bree's daughter, Kylie, during COVID. He always treated Kylie like his own daughter, as we treat her as a granddaughter today. Neighbors of theirs told us they never saw Bree doing anything with the kids, but Collin was often playing with them. Bree's parents told us more than once that Collin was the best thing that ever happened to her and to helped with her stability. When we first heard of Collin's death, without hesitation, we knew we had to care for JP and Laney. I'm happy to say they are thriving. They're doing well academically and in their citizenship. They're surrounded by church, neighbors, friends that love them deeply and will do anything for them. Collin's friends keep in touch with us and offer whatever they can do to help the kids. My prayer for them each night is that they will know God, love God, serve God and his children. I'm confident that Kylie, Brody, JP, and Laney will make a loving impact on the world. All our family ever tried to do was love on Bree and make her part of our family, but she couldn't accept that for some reason. Bree has never once showed remorse to us, sympathy, empathy, comfort, or consolation. If Bree were to go free at some point, I am concerned for our lives. She's continued to have an adversarial relationship with us, and I believe she would seek out to murder us as well. Her personality is such that she must win at all costs. I have the same fear for Collin's son from another marriage, Brody. Most important part of this whole letter, of one thing I am certain, we serve a God that loves us so much that he gave his son to make a way that we could spend eternity with him and with our loved ones. I am confident that I will spend eternity with Collin. Our prayer is that God would make himself real to Bree and her family, and that she will join our eternal family. I have some pictures, Your Honor.
Okay. Any questions?
No questions.
Okay. Mr. Alderman, do you want this as part of the record?
Mr. Turner?
Sorry.
Yes, Judge, if you want to make those part of the
Okay, we'll admit those as,
Victim impact statements.
yes, as impact statements, yes. Mr. Alderman?
No other witnesses from the state, Judge.
Okay. Mr. Etheridge, Mr. Barnes?
No, we have no evidence to present to the court. That was mentioned.
Okay.
Judge, and this is to raise victim impact statement
Okay, all right.
that she's already read. I'll make that part of the record.
Okay, we'll make this additional victim impact statement part of the record. Okay, anything else from either attorney?
No, from the state, Judge.
For the evidence or testimony,
Okay. Having been found guilty of first-degree premeditated murder, the court imposes the following sentence. I'm going to adjudicate her guilty, sentence her to life in prison. There will be $518 in mandatory court costs, a $210 fine, for a total of $728. She would get credit for all time served. That's the judgment and sentence of the court. She has 30 days in which she can appeal. If she cannot afford an attorney, one will be appointed for her. Anything else from any of the attorneys?
No, from the state, Judge.
not by defense.
Okay. Court is adjourned.
Please rise with the judge.